take that live now.
The Apex Court ruled in the following terms, I quote, "The Constitutional Court has considered the application for direct access and rescission. It has concluded that there is no need for directions to be issued in terms of Rule 18 sub 4, calling for written submissions and or answering affidavits. The court has concluded that the rescission of the judgment, there are also no exceptional circumstances that warrant the rescission of the judgment. Therefore, the court has concluded that the application should be dismissed as no case has been made out for rescission. The court has concluded that the application for direct access should be dismissed as no case has been made out for direct access. The court has decided not to award costs." Close quotation. At paragraph 29 of our judgment, the following issues require our attention. A, the striking out application. B, whether the applicant is entitled to an interim interdict pendente lite. C, whether res judicata or issue estoppel is relevant. And D, if any of the National Assembly rules support any basis for the relief contended for by the incumbent. Paragraph 30, under the heading Interlocutory Applications, we state the following. There were a host of interlocutory applications filed. In addition to those filed prior to the hearing of the matter on the 18th and 19th of May 2022, the applicant filed a post-hearing application to amend the relief sought in the notice of motion. The only interlocutory application that was contentious in any manner related to the application by the applicant to strike out parts of the unsealing papers of the first, second, and fifth respondents in terms of Rule 6, sub 15 of the Uniform Rules of Court. That application remained opposed. Under paragraph 30, I read a portion thereof. We are of the view that insofar as this issue relates to the first respondent's affidavit, the following: A, the impugned passages are not in dispute, and B, they are already in the public domain and of significant relevance to the issues to be decided. At paragraph 32, in connection with the application aimed at the affidavit of the third respondent, in brackets the President, it related to A, the various pending investigations in which the applicant allegedly failed to make a full disclosure, and B, the timing and status of the investigations which go to the question of the avert conflict of interest. We do find it rather curious that the applicant moved to strike out documents that originated from our own office. Paragraph 33, we hold the view that there is no merit in the application for the striking out of any of the information as contended for, and that it is hard to discern why the applicant would take up the position that she did, having regard to some unfortunate emotional outbursts and intemperate language put forward in her own affidavits. Paragraph 34, having regard to the Apex Court's dismissal of the rescission application, Advocate Mqwebani nevertheless again sought to challenge and set aside the order granted on the 6th of May 2022 for the following reasons. A, that it is no longer feasible for the proceedings of the inquiry committee to continue, B, that there is a jurisdictional bar to the present application pending the outcome of an investigation, and C, the true and final state decision of the rescission application is unknown, in inverted commas, pending the outcome of the investigation. Paragraph 35, in the most recent application, the new rescission application piloted by the applicant to the Apex Court, of the Chief Justice authorizing the release of the order dated the 6th of May 2022, in brackets, prior to the outcome of the investigation, to be invalid. B, an order declaring the request by the first respondent for the urgent disposal of the rescission application to be invalid. And C, an order that the failure to further respond to the applicant's letter in this connection is to be declared to be invalid and unconstitutional. At paragraph 36, in summary, the applicant seeks a further order from the apex court to rescind and reconsider the prior order dated 6 May 2022. In the further alternative, an order is sought to develop the common law so as to cater for the new rescission order sought on the basis of alleged irregularity and criminality, which taints the legitimacy or legality of the order and negatively implicates the impartiality of the decision-making persons or institution involved therewith. Simpliciter, the applicant requests that the final order granted by the apex court be set aside yet again by way of another rescission process. I then move on to the parliamentary challenges, and I will read from paragraph 38 and 39 of the judgment. The case against the parliamentary respondents is buttressed by the argument in connection with the pending new rescission application, which the applicant says prevents the impeachment inquiry committee from progressing with its work. The inherent problem with this argument is that any application for rescission does not automatically suspend the operation of a court order. Put in another way, it legally has no effect on the execution of a court order. The authorities on this latter issue are crystal clear that the mere launching of an application for rescission does not automatically suspend the operation of the underlying order. This position in law has since been confirmed in numerous judgments. If this was not the case, as a matter of logic, it would have resulted that the mere filing of an application for rescission, even a groundless one, would impede the operation and execution of court decisions and court orders. Paragraph 39, I will only read the first sentence of the paragraph. The rule of law stands to be completely eroded and undermined if this position was to be accepted. I turn to the legal issues of res judicata and issue estoppel, and I will read from certain paragraphs, only portions thereof, for purposes of delivering this judgment. Judgment will be available immediately after. Paragraph 45, issue estoppel applies where an issue of fact or law was an essential element of a prior final judgment. The issue cannot be revisited in subsequent proceedings before another court, even if a different cause of action is relied upon or different relief is claimed. That having been said, it is indeed so that our courts have recognized that a strict application of issue estoppel could result in unfairness in some.
Well, unfortunately, we have to cut out of those proceedings. That's where we're going to leave it. But of course, SABC News will continue to bring you that judgment.